Is fixed-term appointment legal? Bombay High Court judgment by C-Quel. The Bombay High Court has ruled that when fixed-period appointment is not made with mala fide intention or colorable exercise of power, provisions of Section 20BB and Chapter 5A of Industrial Disputes Act, 1947, ID Act, would not be applicable. Case, Lokmat Shramik Sangh Panavi Member, Industrial Court, Nagpur and another, writ petition number 4206 of 2009. The Bombay High Court held that if the contract of employment is for a fixed period, the appointment is terminable at the end of the period of the contract, and such appointment is not made with mala fide intention or colorable exercise of power, then in view of Section 20BB of the ID Act, the provisions of Chapter 5A of ID Act would not be applicable, even if a workman has completed 1 year of service as on the employment termination date. Section 20BB of the ID Act provides that retrenchment, which is termination of employment by employer, does not include termination of the services of the workman as a result of the non-renewal of the contract of fixed-term employment between the employer and the workman upon its expiry. Further, Chapter 5A of the ID Act sets out provisions related to compliances required to be undertaken by an employer in cases of retrenchment and layoff. In this case, individuals were employed on a contract basis for a fixed period of 1 year or less at a time, which contract was extended or renewed year on year. These employees were given grades/pay scales different from similarly situated permanent employees. The requisite pleadings concerning the permanent nature of employment were not found in the statement of claim. Accordingly, the court opined that a mala fide fixed-term employment arrangement cannot be assumed. The situation might have been different had the individuals pleaded misuse of power on the part of the employer. In such case, the burden to prove otherwise would have fallen onto the employer. Any questions? Ask C-Quel.